You know, here in Oregon, we have a long and much loved tradition of being able to create citizen petitions and pretty much pass our own laws without the help of the legislature. But sometimes putting those laws into action, that can be a bit of a bumpy ride. And no, I'm not talking about our drug decriminalization law, Measure 110, although I guess it does apply there as well. Instead, I'm talking about the gun control law, Measure 114. It's facing some big constitutional questions, but even when those are worked out, a small but still important side issue may still trip it up. And that's our big story tonight. We're still waiting to hear from the state judge in Southeast Oregon on that big question, whether he thinks Measure 114 violates the state constitution. The court case is keeping the measure on ice for now. But even if the judge decides it does not violate the state constitution, it could still be in trouble. And not because of the appeals, which have basically been promised at this point, but there's a very good chance the FBI will not run background checks, which is explicitly required under Measure 114. Now, I recently talked with the FBI special agent in charge of Oregon, Kieran Ramsey. He said the Bureau wants to help, but until the wording of 114 is changed, he says it's not able to get involved because of a federal law controlling which groups it can share criminal background information with.
In Section 4 of Measure 114, it says that it authorizes state and local agencies, specifically state and local law enforcement agencies, to receive this criminal background information, and then it adds, or their quote-unquote designee.
And that's the problem.
We can't define or designee because the only agencies that we are allowed to share back our criminal investigative background information is with, in fact, state and local government agencies. Generally speaking, that's law enforcement agencies, but it could be other government agencies. But in this case, that or designee is an issue. Could that be a private party? If that's the case, it doesn't comport with 92-544.
Okay, because the federal law says you can't share it with a private party.
It says that we only can share it with state or local government agencies. And that's where this becomes, again, very nuanced. It's not about us not wanting to work with the Oregon State Police. I have a great relationship with the Oregon State Police. It's not about wanting to work with the sheriffs or the chiefs. We have phenomenal relationships across the entire state. It's not even about working with the state of Oregon. We work with, in fact, a lot of different agencies within the state of Oregon's government structure. It's simply Measure 114 has to comport with Public Law 92-544.
All right, well, the wording in the actual document is not quite as clean as he presents it there, but let's take a look and you'll see what he means. At the top of Section 4 for Measure 114, it says, a person may apply for a permit to purchase a firearm or firearms under this section to the police chief or the county sheriff with jurisdiction over the residence of the person making the application. And if it had stopped there, the FBI would probably be fine with that part of things, but it doesn't. It goes on to say, or their designees, which is what throws a monkey wrench into the eyes of the FBI. Farther down the page, and still under Section 4, we see the permit agent, which remember could be law enforcement or their designee, which means that could be someone who's not law enforcement, shall request the department to conduct a criminal background check, include but not limited to fingerprint identification through the Federal Bureau of Investigation. And the FBI argues if that was followed through, the designee, again, maybe somebody not in law enforcement and not an official of the state or local government, well, that person could get the results of the criminal background check, and that would violate the public law that he mentioned. Now, I looked up that public law. It's kind of detail-y, but here it is, good old Public Law 92-544. It was written to allow the FBI to help by running national criminal background checks for non-criminal licensing or employment issues, which this is. And it states right at the top that the FBI is empowered to exchange identification records with officials of state and local governments. They underlined those words, by the way, not me. But that would include law enforcement and others, but not, for example, the owner of a gun store or any other civilian. So that's one of the big issues the FBI says they have with Measure 114 implementation. Someone not in law enforcement or not an official or state of a state or local government could get the results of the criminal background check the way Measure 114 is written today. And while we're looking at the FBI's arguments for not running those background checks, here's one other problem they point to. Back with our old friend, Public Law 92-544, it says the FBI can share records if authorized by a state statute. And then below that, it says the state statute must exist as the result of legislative enactment or its functional equivalent. Now, the FBI legal folks are apparently trying to decide if a referendum passed by the people of Oregon is a legislative enactment. I'm going to guess it's not. Or the functional equivalent. On that, I'm guessing the answer is yes. Not that anybody's listening to me, but it does make sense. I asked Ramsey whether the FBI offered advice to the people who drafted Measure 114 before all the words were set in stone.
So generally speaking, and I don't want to speak to any ongoing discussions or even discussions before, but generally speaking, the FBI's Office of General Counsel and the Department of Justice make themselves very available when state laws such as this are being proposed. So I know that was the case here in Oregon. I know that's the case across the country because Oregon is not the only situation that something like this is being faced. My concern, though, has been this claim that, well, the FBI is flatly refusing to do this. That's just not true.
The other piece, so what would Oregon's legislature have to do to make it okay?
I don't have a really solid answer for that just yet because, again, there still has to be some legal analysis. And that's by big Department of Justice, big FBI, not the FBI here in Oregon. But I think the ultimate goal still is, okay, where is 114 not easily comporting with that federal law? And let's make sure that gets there and that there is no ability to claim that this is some lack of partnership on the part of the federal government, let alone the FBI specifically, towards our partners in the state of Oregon.
Okay. You're saying we'll do whatever we can, whatever the law will allow us to do.
Exactly.
Okay.
So even if the Harney County judge rules that 114 does not violate the state constitution, there are still some wrinkles that need to be ironed out before 114 can be fully implemented. And that's not to mention the appeals that will most certainly come no matter which way the judge rules in the near future. With some speculating, this case could go all the way to the U.S. Supreme Court. We'll see. So what do you think about all that? We can tell you one thing, the drama surrounding the measure is far from over. We'd love to hear your thoughts, though. Email us. The address is thestory@kgw.com or call and leave a voicemail, 503-226-5090.